Welcome to the Creditors Report.
Welcome to the Creditors Report with attorney Victoria A. Ferraro, managing member of Ferraro, Hancock & Associates, PLLC. Victoria is a Tennessee attorney with more than 20 years of experience representing creditors and financial institutions in bankruptcy, collections, repossession, and foreclosure matters across the state. I'm Chelsea, and today we're talking about how bankruptcy affects secured transactions and what happens to liens once a borrower files in Tennessee. Welcome back.
Hi, thank you so much.
First, could you give us a quick refresher on what a secured transaction actually means in the context of creditors' rights?
Yes. So a secure transaction is a transaction or a loan of some sort, a credit extension that is backed by collateral. So let's say you go and you buy a car and you enter into a retail installment sales contract and you're going to give a lien if you financed it with somebody to the creditor, and that means it's backed by the collateral. So the payment of that debt is backed by the collateral, so that if you default, a creditor can set off against that collateral in order to recoup that debt.
When a borrower files for bankruptcy, what's the first thing a creditor should review to understand how that filing could impact their lien position?
So the very first thing that they should review, depending on the chapter. But in our first episode, if people saw that one, we talked about the bankruptcy notice. And in that bankruptcy notice, we talked about the fact that there's going to be a lot of deadlines in there. And one of them is the meeting of creditors, and the other one is the proof of claim deadline. So when somebody files bankruptcy, that proof of claim deadline is going to be super important for putting your lien before the court and letting them know where you are. So the very first thing that they should do is file a proof of claim. And that proof of claim is going to tell the court how much they're owed, and is going to attach documents, or should attach the documents. It better attach the documents. It's a better way of saying it. That are the contract and the perfection documents. So either a UCC or the title or something of that nature that shows that they have a lien, and is it perfected? In other words, the collateral, the documents themselves, the contract itself that the debtor signs is going to grant the secured creditor a lien. But in order to be protected in bankruptcy, that lien has to be perfected. In other words, it's got to have notice to the entire world that creditor A has a lien on that car. So they need to get their contract before the court. They need to get their lien information, their UCC or their title before the court, so that there is notice not only to the world but to the bankruptcy court that they do have a secured and perfected interest.
Okay. And how does bankruptcy code generally treat perfected liens, and what kinds of mistakes can cause a creditor to lose that protection?
So let's start with the second part of that question, the losing of it. If a lien is not properly perfected or not perfected at all, then they're going to lose that lien. So what does that mean? In the state of Tennessee, liens on a car can actually be perfected at any point, but to be properly perfected in a bankruptcy court, they have to be perfected within 30 days from the contract date. That's called the relation back period. If they were perfected during that 30 days and within the 90 days before bankruptcy, which is called that preference period, then they're going to be properly perfected. UCC is going to be the same thing, that it needs to be properly perfected within that time period. So one of the things that can happen to lose that is that they weren't properly perfected. So either the lien wasn't done at all, or it wasn't timely done. And so that's going to cause them to lose that lien. In the event that the debtor files bankruptcy and the lien is perfect and it's been properly perfected, and they have all the required documentation to demonstrate that, then the bankruptcy code generally and genuinely respects liens. So under 11 USC 506, secure creditors have the right to be valued up to the amount of the value of that collateral because they have a secured lien. Under 1325, under BAP-CIPA, the new code that went into effect in 2005, secure creditors now have a lien retention provision that they're going to maintain their lien until the earlier discharge of the Chapter 13 or the payment of the underlying debt. So the code as a whole provides protections for secure creditors that have properly perfected security interest.
And you've reviewed countless vehicle and equipment files over the years. What are some of the most common perfection or title issues you see when those loans end up in bankruptcy?
Well, the one is the one I just touched on. So usually it's that it's not timely perfected. So the preference section of the bankruptcy code is 11 USC 547. Within the scope of 547, if a lien was perfected outside of the 30 days from the contract date, so that relation back period, and within the 90 days before, then you're fine. But if it was perfected outside the 30 days, I've had some perfected on the 31st day and within the 90 days, then that is not properly perfected. And that's going to be a situation, that's going to be something that causes them to have an issue with their lien.
Wow. How do things differ between Chapter 7 and Chapter 13 when it comes to how liens are handled or stripped?
So in a Chapter 7, the trustee is going to be the one that looks into the liens. If a lien is not properly perfected, then a Chapter 7 trustee is going to want to take in that collateral and sell it for the benefit of unsecured creditors. So they will do their due diligence. We have a great Chapter 7 trustee panel within the entire state of Tennessee. Most of our trustees are, beyond excellent. And they exercise their due diligence and they look at the contracts and they look at the liens. If the lien information gives any type of question about whether or not it may or may not be perfected, then they will send a notice out under 3001, Rule 3001, and they will ask for more documentation to show whether or not that lien is perfected. If that lien is not perfected, they do reach out to sell that collateral, take it in-house, sell it. The proceeds will be distributed to the unsecured creditors, and the secured creditor will their lien will be avoided. There's a lot more of a process than that. It takes an adversary proceeding unless somebody wants to do an agreed order, but that the lien will be avoided because it's not properly perfected. Within the scope of a Chapter 13, usually you can actually enter into a different type of agreed order. So the order within the context of Chapter 13 is going to allow the debtor to retain possession of that car throughout the life of the Chapter 13 because they need it. They need it to reorganize their Chapter 13 and to continue working and making payments on that Chapter 13 case. So that agreed order is going to allow the debtor to keep the car. And the creditor, providing the lien was not properly perfected, and we can go into more detail about that if you want, but we'll enter into an order that says, okay, we will avoid our lien. We'll agree that our lien is subject to avoidance. But we want to retain possession of the title unless the debtor completes payments and gets discharged. Debtor gets to keep the car. We don't get any payments in the Chapter 13. But if that case is dismissed, then under 11 USC 349, our lien is reinstated. And then we don't have an issue. That 11 USC 349 is super important in the context of a Chapter 13. And if a creditor does enter into an order, that provision needs to be in there because it does reinstate their lien upon a dismissal. And so a lien that was not timely at one time is now going to be timely by virtue of a later petition date. So that's a big difference within the context of the difference between a Chapter 7 and a Chapter 13.
You touched on this term already, but can you explain the concept of lien avoidance when a creditor might see that raised in one of the cases?
So lien avoidance is where their lien is actually stripped or taken away. And it's because typically that their lien was not properly perfected, not timely perfected. And so in the course of a UCC, it could be that the UCC was valid, but that it was not properly continued under Article 9, which means that it was not a continuation statement wasn't filed within the 5 years to extend that UCC. Or it might be that with a certificate of title on a car that it wasn't timely perfected, as we've already discussed. So in those situations, an adversary proceeding can be filed. It takes an adversary proceeding to, unless there's an agreed order entered into, it takes an adversary proceeding to avoid that lien. And an adversary proceeding can be filed to avoid the lien and strip that off, so that now basically that secured creditor is now an unsecured creditor.
For lenders managing high volume portfolios, what systems or checkpoints help ensure liens stay properly perfected before a bankruptcy ever happens?
One of the biggest things that that we have seen and that is helpful is just vendor oversight. Just making sure that the vendors that the creditors, the secure creditors are using, are making sure that these liens are perfected and timely. Make sure that they know the requisite guidelines that they have and the timing factors that they have to get those liens perfected in. Vendor oversight is huge. Another one is just an automatic or automated UCC filings. So make sure that there's a note or a process within your computer system that when that that the original UCC was calendared, and that there's a deadline that's going to pop up that says this needs to be renewed, and so that it is renewed in a timely fashion. So that's very helpful with our clients, that when they have these automatic systems that will just pop it up for them to let them know that it needed to be renewed. And some of the systems will actually go ahead and send out the renewal statement themselves, the continuation statement themselves. Another one is document retention, just making sure that they have all of their documents in a safe place, and to make sure that they are as organized as possible and readily available in case they need them to show that their lien is protected.
What practical steps can creditors take during a bankruptcy case to reaffirm or defend their lien rights without driving up unnecessary costs?
To reaffirm or defend their lien rights. So I mentioned earlier today that the trustee, and I only put it in the context of a Chapter 7, but the Chapter 13 trustees actually send these letters out too. So under 3001, if there's a question about a lien, a trustee will send out a 3001 letter. When the creditor gets that letter, they need to exercise their due diligence and make sure that that lien is not perfected. Sometimes the face of a title will give the impression that it was not properly perfected. It might be outside the 30 days and within the 90, as we've already talked about, that 90-day preference period. But at the end of the day, it actually is timely perfected. So in the state of Tennessee, we have what's called a temporary lien. And that temporary lien is a piece of paper that the dealer can fill out, or the seller of the car, and send it into the Department of Revenue, the county clerk, whichever one. Pay $10, I think, is the fee. It's minimal. And that lien will be perfected for 180 days until the actual title is issued with that lien on there. So when a creditor gets that letter, they need to go back and make sure with the dealer or with the seller of the car that temporary lien wasn't done. They need to exercise their due diligence in ways like that to make sure that their lien actually isn't perfected. Don't just take it on a grain of salt that your lien's not perfected. Actually do the research, look into it, because there's so many times that we've actually shown that the lien was perfected, and on the face of whatever document it appeared not to be. So that's the biggest thing that I can say is exercise your due diligence and do your research.
Finally, if a creditor discovers after filing that a lien wasn't perfected correctly, is there ever a path to fix it? Or is that door usually closed once the bankruptcy begins?
Yeah, that door is typically closed. The filing of that bankruptcy pauses, as we've already discussed, and that door on being able to perfect your lien typically closes. Now, if the contract was done within the 30 days before you file bankruptcy, under 362B, there is a mechanism for being able to still maintain, to still move forward on perfecting your lien. So that's something that can be done. So look at the timing of it. Look at the timing of your contract and see if it was done during that short little window so that you can still maintain moving forward with the perfection. Again, look for that temporary lien. If the temporary lien was in place, you can still move forward with the perfection because you were perfected. You were timely perfected to begin with. But for the most part, besides those small exceptions, that the filing of the bankruptcy usually does close that door on being able to fix a lien issue.
Mm. Thank you so much for the insights today. That's it for today's episode of the Creditors Report with Victoria A. Ferraro of Ferraro, Hancock and Associates. To learn more about how Victoria and her team protect creditors' rights across Tennessee, visit fhalegal.com. Thanks for listening, and be sure to like, leave a review, and subscribe to the show so you don't miss the next episode. See you next time.
Bye.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.